Know the difference with Annex Wealth Management? Alec Durand is an estate planning attorney at Annex. Welcome back, Alec.
Thank you, Danny.
Many people wish to pass assets upon death to their family, often their children. That can get complicated quickly when the family in question is blended. It's important to make sure that an estate plan aligns with goals and intended beneficiaries. And let's start there. When a family is blended, what is the wise way to approach estate planning? Now, some can do it before marriage, others do it after. I'm not the lawyer, you are, but it would seem to be cleanest to get the details in order before the union.
You know, it's a great point, and I think in an ideal world, yes, that is the approach. But the fact of the matter is, if you don't know the law, you don't know any better. And there's nothing wrong with doing planning after the fact. You just have to make sure that you get the planning done properly. If you're thinking about these things beforehand, then setting out an agreement or getting something done before you actually enter into the marriage can absolutely help with clarity down the line.
Does a trust or a will consider children and stepchildren having the same rights?
Trusts and wills can define what a child is. Generally speaking, though, the law is going to have its own definition of what a child is. Most often, a child is a biological child or a legally adopted child, which means that where the stepchildren are involved, they could be cut out, which can be a problem where that emotionally is a person's child. But the emotional difference that you and I have can vary wildly from the legal definition.
How about a marital property agreement? Where does that come in?
It can come in at any time. It's just going to be called a different thing depending on when it comes in. So if you enter into one of those agreements before the marriage, they're going to call it a prenuptial agreement or a prenup. If you enter into it after the marriage, they'll call it a postnuptial agreement or sometimes just a marital property agreement. And the purpose of that is to help define what's considered what for what person. Is the house yours? Is it mine? Is it ours? Right? So that's the purpose, and it can really help guide where property is supposed to go when people pass away.
We're with Alec Durand, an estate planning attorney at Annex Wealth Management, talking about estate planning for blended families. More evidence, I'm not a lawyer. So you told me generally, account ownership and beneficiary designations do not eliminate statutory rights granted to spouses. I had to write that down. You want to decode that for the rest of us?
Sure. The law in most states is going to define what rights married persons have. Those rights aren't going to get changed just because you leave your spouse off of an account. You're still going to have rights under state law. But where account titling and the beneficiary designations don't match up with those default rights granted to spouses, it can cause some friction down the line. That's where planning ahead of time can help make sure that everything's seamless. It aligns together and assets flow where they're supposed to go as intended.
Do assets and property generally stay on the side of the person who brought them into the marriage, or does it need to be legally defined?
Generally, yes, but this is one of those sticky areas where it can get very complicated very quickly. Now, every state's going to have its own laws regarding what's going to be a marital property and what's going to be individual property. Not every state is a marital property state. Where you live is going to change a lot of these rules. But generally speaking, if you come into the marriage with it and you keep it on its own and you don't mix it with anything that could be considered marital property, it will be individual. Again, these rules can get very, very complicated very, very quickly.
Here's a complicated question. In a case where the worst happens, one of the spouses pass, how firm is the estate plan put in place by the couple with the blended family with the distribution property remaining in place? Meaning, one spouse passes, can it be changed and perhaps even disinherit?
Yes, is the short answer there. The idea behind doing solid estate planning is making sure that everyone's on the same page beforehand. And you're trying to figure out where could things go wrong down the line so that you're not coming into this issue. If there's nothing in place, it's easy to change it when one person passes away. If you have nothing in place, it's also very easy for unintended consequences, accidental disinheritances to also come into play. That's the real kicker here, is you want to get in front of this ahead of time so that your property is going where you want it to go, who you want it to go to.
I think you've answered the question, but is this the way that we counsel our clients?
Absolutely. We want to be thinking about these things ahead of time. You don't want to have to run into something after the fact of going, well, my wife meant to do this or my husband meant to do this. Well, what someone meant to do and what the law says is going to happen can be very different, and we hate to see that happen. We want to get in front of the ball on it.
Alec Durand is an estate planning attorney at Annex Wealth Management, working on behalf of our clients on this and other matters. Thank you very much.
Thank you.